Hello guys, and welcome to another episode of my lecture. On today's episode, we will be talking about admissions by persons expressly referred to by a party to a suit. In my last class, I talked about admissions made in a representative capacity, and I told you that there are two elements that must be fulfilled, and the moment those two elements are fulfilled, then those kinds of admissions are valid admissions. In this class, we'll be talking about admissions made by persons expressly referred to by a party in a suit. Section 23 seems to govern that, and it provides for the admissibility of admissions made by a person to whom a party to the suit has expressly referred to for information. Statements made by persons to whom a party to the suit has expressly referred for information in reference to a matter in dispute are admissions. In other words, admissions made by references are binding on persons making the references. In the case of Williams versus Hine, which is the authority for this rule, the defendants were executors of the deceased persons. If you don't know who an executor is, when a person has died, he would appoint certain people in his will. That means he died testate. He would appoint certain people in his will that they should help him carry out those things that he has stated in his will. Those people are the executors of the will or the executors of the deceased estate. So in this case, the defendants were the executors. They referred the plaintiff to R for information concerning the deceased. The court held that what R said could be proved against the defendant. Now, this is very, very easy and straightforward. It's not complicated any bit. We are saying that where the parties to a suit, A and B, A is trying to prove a point to the court, and A is saying that, my lord, C, tell B to go and meet C. When B meets C, C will tell B certain things. However, this is where it becomes tricky. Now, when A is saying that in court, A is saying that with the mindset that he's going to win the case, yeah? Because obviously, you will not tell B to go and meet somebody, that is C, to come and tell you things to use against A, obviously. But now, let us say that there is now a reverse of the case. So, A told B to go and meet C. And then C now made certain admissions, which is fatal to A's case. Maybe before B met C, A had not told C the format. Oh boy, these are the things may you talk. Oh, no go talk this, no go talk this, no go talk this, and stuff like that. A did not tell C that. Just imagine that A did not tell C that. So C, maybe he was in a happy mood that day. He was just jam talking, saying this, saying that, saying this, and B was just writing, wow, wonderful, great, and stuff like that. And then B now got to court the next meeting or the next adjourned date. B got to court, and then B decided to tender those things. Then A objected and said, my lord, no, this one is fatal to my case. No be so it's supposed to be. My lord will say, have you gone to section 23 of the Evidence Act? My lord will say, have you read the case of Williams versus Hines? Because if you have, you would know that any admission made by a person who was referred to by a party in the proceeding will definitely be used in that proceeding, regardless of the fact that he hurts the party who referred. That is A in this context. So if you look at that particular case, the court will say, Madam Lawyer or Oga Lawyer, did you go to law school? Did you study your law of evidence? Because those are the questions you need to ask. You were the one that said that they should go and meet C. Now B has gone to meet C, and C has given B certain information that is now detrimental to A's position. And A is coming to say, no, it shouldn't be used. B can rely properly on the authority of section 23 of the Evidence Act to say yes, regardless of what C has said, regardless of the fact that A pointed B to C, whatever C has said should be used against A in any proceeding. And with that, I hope it's very, very clear. When the party tells the other party to go and meet another person for information, like we can see in the case of Williams versus Hines, whatever the other party has come to say, the court can admit it even when it is detrimental to A's position. If it's not detrimental to A's position, of course, A's aim is then achieved for B to get the information from C. But where it is detrimental to A's position, that's the time that A is very likely to object to the admissibility of such admissions by C, and the court is more likely, especially in the face of section 23 of our Evidence Act, to overrule such objection and uphold whatever C says as a valid admission as against A. And so with that, we go to my next lecture, which is a lecture that I call Liability X against A admissions. Liability X against A admission is quite complex, which is the reason I gave it that name. But do not worry, in my next class, I will break everything down to tiny bits and make sure that you understand it to the best of my ability. So I will see you, therefore, in my next class.